Good afternoon, everyone. Welcome and thank you for joining us this afternoon. My name is Albert Yoon, and I'm a law professor at the University of Toronto Faculty of Law and the Associate Dean for Faculty Research and Curriculum. This webinar is hosted by the Faculty of Law, University of Toronto, a vibrant intellectual community that is home to a diverse range of ideas and approaches. The faculty's status as one of the very best law schools in the world rests on its excellence and diversity of our faculty, robust clinics and centers, and the caliber of our students. Today's session will be hosted by Benjamin Reese, supervising lawyer for housing law at Downtown Legal Services, the Community Legal Center at the University of Toronto Faculty of Law. Just a few words about the Downtown Legal Services, or DLS as it's known at the faculty. It is both a community legal clinic and a clinical education program operated by the Faculty of Law and the University of Toronto. Our free services are provided by law students who work under the close supervision of our expert staff lawyers. Approximately 140 law students work at the clinic every year, enabling us to serve over 2,000 clients. Ben has spent most of his career working in our province's community legal and clinic system and returned to DLS in 2014 to lead the clinic's housing law division, where he originally started as a law student back in 2006. Ben's students litigate and negotiate on behalf of the student renters and low-income households primarily before the Landlord and Tenant Board, the Ontario Human Rights Tribunal, and the Small Claims Court. They also engage in tenant organizing, outreach, and law reform efforts in partnership with other legal aid clinics and partners in the justice, social service, and health sectors. Ben, thank you, and we look forward to your talk this afternoon.
Great, I'm unmuted. Thank you, Professor Yoon, for that introduction, and thank you all for tuning in. Today's presentation is largely aimed at colleagues with formal legal training who may not be specialized in housing law or rental housing law. Maybe you are a renter, maybe your child or a friend is a renter, and you may be getting some questions about what the sort of changes that have come about as a result of COVID-19 mean for tenant rights. And so that's where this is aimed, although anybody who's gone bowling with me knows that I often hit targets that I wasn't aiming for. So if you don't have formal legal training, you may still find this useful. And I commend to anybody who doesn't have any legal training, Steps to Justice, the website stepstojustice.ca, which has great explanations in plain language of quite complex aspects of law, especially as they've changed under COVID-19. We're going to go over quickly the statutory and regulatory context for renters in Ontario for the most part, and then I'll riff on some issues or aspects of that regime that I think have been most affected by the pandemic. We'll speak a little bit about the role that DLS is playing and will play in the coming months for renters who were able to assist. And then we'll take some questions. So please go ahead and type your questions as you have them into the chat. I can't promise that I'll be able to answer all of them, but we'll do our best with the time permitting. Okay, so for anybody who took property law, this may be reaching back somewhere into your brain. We have sort of a common law regime in Anglo-British jurisdictions that distinguishes between leases and licenses. And in Ontario, the lead case is still BA Oil that says that really we have to distinguish between just a mere license to occupy a space that a business or an individual might get. And that's just a contract. That's a person whose contract can be terminated, and while there may be litigation about the termination of that contract, they don't really have an interest in property. On the other hand, a common law lease was always an interest in property, and the main determining factor was, has a person been given exclusive possession and control over some kind of space. Since 1970, we've had statutory regulation on top of that of tenancies in Ontario, which I think really boils down to three main features. Security of tenure has restricted, ever since 1970, the ability for landlords and tenants, for that matter, to end tenancies according to only certain procedures set out in statute, and for only certain reasons, at least on the eviction side in statute. So where that's taken us now, obviously, under the Residential Tenancies Act is a sort of final successor legislation of everything I've put up on the slide, is a list of grounds of termination of a tenancy that are all, they all correspond to special notices of termination that the Landlord and Tenant Board publishes, and that landlords are required to serve on tenants in order to end the tenancy for the specified reasons in those forms. Otherwise, tenancies automatically renew on a month-to-month basis if the rent is paid monthly at the end of the initial term of the tenancy. So that's security of tenure. Covenant control, part and parcel with that ever since 1970, has restricted the terms and conditions of the lease agreement that is really entered between a landlord and tenant. So the statute has said and still says that any lease covenant that a landlord and tenant in the residential context enter that is different from the statute is void. The statute, everything must be consistent with the statute, and the statute is nearly, I would say, a complete code, other than setting the amount of rent and what's included in the rent in terms of services and facilities. Beyond that, landlords' rights and tenants' rights are fixed in statute for everybody, everybody who's covered by the RTA. Finally, we have a system of rent control that has actually evolved into vacancy decontrol, meaning that for anyone familiar, you know that there's a limit for most tenants on the amount that their rent can be increased, and it can only be increased annually. That is no less than a year from when the tenant first moved in or when the last rent increase happened. It has to be with notice, again, published by the Landlord and Tenant Board, a form that has to be served on the tenant within a certain amount of time. And at a high level, that maintains rents at sort of an inflationary growth rate within each tenancy. But as soon as a tenancy ends, as soon as a unit is vacant, the next tenant who moves in will pay whatever rent, we call it market rent, whatever the landlord is able to convince the tenant to agree to pay, and that can be sometimes double or triple what the previous tenant was paying. But that's the current regime that we're in, and it's been that way for a couple of decades or more. So those are the kind of main features, and the RTA applies to nearly, or I would say, the vast majority of tenants. But we can talk about a few other renters that might not be covered by the RTA. So rooming house tenants, whether you're renting just a room or whether you're renting a whole apartment in a condominium or in a house or a whole house, all of that is generally covered by both the RTA and the Human Rights Code. Social housing gets a different regime for how the rent is calculated and increased, and that's so that we can have rent geared to income subsidies. Cooperatives are covered by only the part of the RTA that creates a procedure for terminating a member's occupancy rights in a housing co-op. Otherwise, they are still governed by the Human Rights Code, but that's an alternative to the rest of the rights contained in the RTA. There are either complete or partial exemptions to the RTA depending on the type of university residence that a student lives in, and I put that on the chart. And then there are sort of further exemptions from the RTA, but the most commonly known exemption, and the one that's come up in the news a little bit lately, is a rental situation where the tenant is required to share a kitchen and or a bathroom with a member of the owner's immediate family or the owner themselves. That is not only completely exempt from the RTA, and we'll call those people boarders, it's also exempt from the Human Rights Code. So you're allowed to discriminate against your own boarder in a variety of ways under the code. And then there's just this further question, I think, at common law, rolling all the way back to that to BA Oil, as to whether or not the tenant in that situation has a mere license to occupy like the front room of the house, or whether we can say that there's enough space that even though it lacks a kitchen or a bathroom, that they have exclusive possession and control, and then they're a tenant, in which case it may be that the Commercial Tenancies Act applies. Doesn't give the person a whole lot of security of tenure, but a little bit more, we'll say, than being a mere licensee. Under this regime, if you're a tenant or if you're in a housing co-op, you're not going to be able to be removed from possession without the legal proceedings, typically at the landlord and tenant board. But if you fall into one of those other exemption categories, you could be declared a trespasser if you're a boarder and you share a kitchen. So that's the way in which, despite the province stopping evictions, which we'll talk about in a moment, that's the way in which some tenants, because they didn't have their very own kitchen or bathroom, have been just kicked out. It's and whether there was a breach of contract would be resolved through proceedings, possibly in small claims court later. It would just come down to who owes damages. But as soon as a landlord in that situation decides that they no longer want the tenant there, they revoke their right to occupy, and that person becomes a trespasser who can be removed by police if necessary. I'll just add a few other things or sources of law that I think are relevant to what we'll be discussing today. There's the effective or near moratorium on evictions that we got in mid-March, and that was accomplished through the order that I've put up on screen of the Superior Court. This is the Attorney General against persons unknown, against anyone who might want to enforce a residential eviction. They are now required, according to this order of the court, to obtain leave from the court before they can get their eviction order enforced. Before that wasn't the case, which we'll talk about in a bit. The Landlord and Tenant Board, this is not a source of law, this is just a press release, but they have suspended hearings and canceled hearings generally, other than for evictions where it's a matter of an illegal act or a serious impairment of safety, and then they are willing to proceed with those, as well as tenant applications, mainly for illegal lockout, although there may be some broadening of that to just safety issues generally. So otherwise, there's nothing happening at landlord and tenant boards. You don't even, if you don't fall into one of those categories as a landlord and tenant, you're not even going to be dealing with the earlier issue of getting leave or having leave granted from the Superior Court to enforce an eviction order. The eviction won't happen. The order won't be made. There's a further suspension under Regulation 7320 that many of us will already have heard about, of limitation periods, and also periods of time or deadlines by which any step must be taken in a proceeding. And in that second paragraph of OReg 7320, it's quite, I think, broad, but the broader category of deadlines that aren't limitation periods is still subject to the discretion of the court, tribunal, or other decision maker. So a big kind of pause button that I think has specific ramifications for some of what we'll be talking about in terms of renters' rights in litigation. So I'm going to dive right into the first issue, which has changed, which is evictions. The normal eviction process under the Residential Tenancies Act, as I said before, begins with a statutorily defined notice that the landlord must serve. And then depending on whether the notice is voidable or not, that will be followed by an application, typically to the Landlord and Tenant Board, although it can be to Superior Court if it's seeking an amount of money over $35,000. And then there's almost always an eviction hearing, except for a very limited set of ex parte evictions, and then an eviction order that is then marched over to the court enforcement officer, the sheriff of the Superior Court. And then they supervise the changing of the locks if necessary, the removal physically of people inside the unit if they haven't already left with a peace officer. And this can lead to either the tenant moving in somewhere else, but I suggest also it is kind of a primary vector into homelessness and all of the places that people can end up as a result of being homeless. And for that reason, I would suggest the order that's been issued and the sort of coordinated stoppage of most eviction proceedings at the Landlord Tenant Board and most enforcement of eviction proceedings in the Superior Court means that, other than the service of notices and maybe the filing of applications with some, who knows how many months into the future you'd get a hearing, that you can see that most of what would lead a person to lose their home has been blocked up and stopped as a result of these really administrative changes to how the system operates. But eviction notices can still be served. There's just some question as to whether or not there's any legal teeth immediately behind those notices. I think that, just to summarize, if you're still going to try to make it through the kind of narrow categories as a landlord available for eviction, you have to file now this request for an urgent hearing. It's a new form the Landlord and Tenant Board has published on its website. And if a landlord files that alongside their eviction application, and the board has said they're really only going to look at N6s and N7s, those are for illegal act and for endangerment of safety, those types of notices. The board is willing to conduct those urgent hearings by telephone. They have the power to do them electronically in writing, but I think for the most part it will be by telephone. And then if an eviction order is issued, the landlord then must make a motion, and it's a motion for directions to Superior Court. And the procedure for that was set out in a case called Morguard Corporation and Corridor that I put the site for on the slide, in order to have a hearing where the court considers some of the same real balancing of interests and safety to determine whether or not this is an order that should be enforced. And we have our first substantive example where the court refused to enforce an eviction order that had been obtained pre-pandemic, and that was in Chalik and Al-Hatam. It was a landlord's application to terminate on the basis of own use, or rather purchaser's own use. And the landlord's contention was that if the court didn't enforce the order and remove the tenant, that the landlord would have losses connected to needing to renegotiate the agreement of purchase and sale. The purchaser wanted to be able to move in as a condition of purchase. And the court didn't consider that enough of a reason to remove the tenant, who had their own delays in getting into the next tenancy, also connected to COVID-19. But if you're exempt from that RTA regime, as I say, there's just still the Trespass to Property Act, which to my knowledge has been unaffected and unmodified by all of the province's response. People can still be declared trespassers, and that can include boarders who will be removed under sort of threat of enforcement by local police. There's then the other way that eviction happens, which is illegally, right? Anybody who is governed by that RTA system, any landlord that nevertheless decides to take matters into their own hands and do what we call a self-help eviction, is going to be violating a number of provisions of the RTA. And the typical responses that a tenant has available to them are to call the police, and the police may or may not assist. Sometimes police say, well, if it's RTA related, we leave that to the Landlord and Tenant Board. We're not going to get involved, and for better or for worse. Call the Rental Housing Enforcement Unit, which is a 1-800 number staffed by customer service officers at the Ministry of Municipal Affairs and Housing. They have the ability to investigate and charge ultimately offenses under the RTA, but I think most of their operational power comes from threatening to do so by phone. And then the tenant also can file an emergency T2 application using the same request for urgent hearing form that I discussed earlier. And that's asking the board for an order putting the tenant back into possession that is also enforceable by the sheriff on an interim basis even. So the concern, of course, is that everything shutting down, and that includes legal clinics closing their doors to sort of public drop-in. A lot of spaces that people in an illegal lockout situation ordinarily rely upon are now limited and unavailable to them. This is, I think we all anticipated right away that this is going to make it very challenging to respond quickly to illegal lockout. And so I've listed some of those problems, and also I think the nature of proving that, yes, I was a tenant here and this is my stuff and this is how it happened, becomes very difficult if you're locked out and you don't have the ability to sort of convey that information by phone. And you don't have as many places to go to do that. But on the other hand, the Landlord and Tenant Board has quite properly cleared its desk, as it were, to be able to respond not only to just a few urgent landlord eviction applications, but also to those tenant applications. And so far, anecdotally, it appears that the idea that's out there that both the Rental Housing Enforcement Unit and the Landlord and Tenant Board are ready and alert to this risk doesn't appear to have led to many, or dare I say any, illegal lockouts. I think we haven't heard of that much happening. Some threats, yes, and there may be a new wave to deal with in May, but so far I would say there's been a lot less illegal lockout activity than we were bracing for in the clinic system. The Landlord Tenant Board has also demonstrated a willingness, at least in one review case, to restore possession, and take into account the risk of exposure to COVID-19 as a factor in terms of balancing the interests and the prejudices to landlords and tenants at the outset of a proceeding like this. Rent strikes are another big issue that have been in the media, and many are aware that as soon as there was a general economic shutdown, many tenant organizers and tenant associations called for a general rent strike. I'll just comment for a second for any legal professionals who are interacting with that. There's sort of this extant ethical issue that we've always worried about and always thought about, which is the rules of professional conduct requirement that a licensee not engage or assist a client with or encourage dishonest or quote unquote illegal conduct. And then that really turns on whether we think withholding your rent is illegal or just breach of contract. And I'll leave it to the philosophy and law experts to debate that. Certainly erring on the side of caution and worrying that, the tribunal in the past, even if the statute doesn't come out and say that a tenant has a duty to pay their rent, the tribunals have certainly treated it as an implied duty, and that deliberately withholding rent is quote unquote illegal. And for that reason, the task for community lawyers to support clients and support clients that are organizing together is a challenging one. And I think the way that most of us in the legal aid clinic movement are approaching this is to say, well, certainly you have an obligation to advise and to document that you advised anyone who asks you about the risks. And the risks are not just being evicted for non-payment of rent or for persistent late payment of rent, but also owing the filing fee, even if you can pay those arrears, the landlord's filing fee when and if this eventually does come before the board. And I think eventually anybody who doesn't pay their rent will likely end up with a landlord and tenant board application for eviction. There's also the risk that tenants who are loudly encouraging others to not pay their rent may be sued for tortious interference with economic relations. But mostly I think that we're not out there trying to convince everybody to pay their rent. That's really up to individual tenants to decide. We're sort of hanging back and sort of saying, we respect tenant organizers' decision making and ability to organize and decide what's best for them. You provide information, and we're here. We're here prepared to protect our clients and our client communities from whatever consequences the law ends up imposing on them as a result of their work. And I think that's a general community organizing and community lawyering approach or ethic that has always existed for any form of civil disobedience. So it's a perspective to share for those outside of the legal clinic system to see kind of the ethical considerations that we see or that we've gone through. But that regulation delaying deadlines that I referred to earlier, I think likely will play a role in how landlords and tenants end up responding to non-payment of rent, whether it's willful or whether the tenant has no choice because they've lost income, which is a situation a lot of tenants are in, and I think most understand that. So some landlord representatives I've seen out there in the media have made clear that they're advising their clients that even though the board's not hearing eviction applications for non-payment of rent, that they think their clients should go ahead and serve N4 notice of termination for arrears, and then go ahead and file if the tenant doesn't pay within the 14-day voiding period. file an application for eviction to get yourself in the queue, as it were, so that whenever the board gets back to having these hearings, I guess you'd be at the front of that very long line to potentially evict or get back your rent under threat of eviction. The caution I'd give, and I think is a concern there that maybe needs to be addressed, is that I don't think landlords are necessarily guaranteed to get their filing fee back if they file on the basis of a notice of termination that they've served now, because the tenant's deadline to void the notice, I think, has been extended by OREG 7320. And if a tenant by the end of the pandemic is able to eventually put together the money that they need to pay their notice of termination, I think there's a decent argument anyway that they have voided that notice and that the board has no jurisdiction to hear an application on that basis. So this is getting into a little bit of inside baseball for people who practice landlord and tenant law, but I think, tenants who are able to pay will, tenants who are not able to pay now, but are eventually later able to pay their rent, may experience some relief as a result of these deadlines being potentially extended in the regulation. But that won't necessarily help a tenant who's accused of, say, persistent late payment of rent, which can happen if you're not paying your rent for several months on end. Then a tenant is really relying on the board's discretion to give them relief from eviction if there's a good explanation for why they, an innocent explanation for why they were unable to pay their rent persistently. Frustration, I think, is another issue. So the Residential Tenancies Act says that the doctrine of frustration of contract and the Frustrated Contracts Act applies to tenancy agreements, but it doesn't do nearly as much work as we'd sometimes like it to, because frustration is defined at common law as sort of an event that wasn't contemplated by the parties that renders performance of the contract impossible. And certainly when a tenant is suddenly loses their job and is unable to pay their rent, that has never counted as the type of impossibility that would frustrate the tenancy. They remain liable. So whether or not frustration gets people out of their lease obligations would probably need to rise to the level, I think anyway, and some of my colleagues seem to agree, of a government order for quarantine or restricting movement that forces the tenant to not be in the rental unit, that forces the tenant to be elsewhere. So encouragements by foreign governments, for example, that foreign nationals who are in Ontario return to their home countries likely aren't going to rise to the level of frustration. They may, they may persuade some people that it would be fair to let those tenants out of their tenancies, but at law, I don't think it's a slam dunk by any means. But there is a bit of a difference in terms of whether or not you're saying that you can't move in and you're pleading frustration, or whether you're saying you can't move out. So a tenant who signed a tenancy agreement and then says, because of COVID-19, I can't move in on the move-in date, is, I think, somewhat more at the whim and sympathy of that landlord, because the act says that you don't have to actually take possession or move in to your rental unit in order for the tenancy to start and for all the obligations to begin. So a tenant who signed a lease pre-COVID-19 and now says, I need to stay where I am. I think in many cases they may still be on the hook for damages, and that's especially so because even though the act says the landlord has a duty to mitigate and look for another tenant, this is suddenly a time when the landlord might justifiably be looking for a tenant and not find one for months. In a hot rental market, we didn't used to worry about that. And similarly, so the tenant might only have an argument about whether their deposit is being kept from them as a penalty or whether it's being applied to their ongoing rent obligations until the landlord can find a replacement tenant. But other than that, I think tenants need to see what their landlord says, I guess, about letting them out of their tenancy or canceling their tenancy. On the other hand, the tenant who gave notice and said, I'm moving out, but has now changed their mind, or they're now not changed their mind, but say they're not able to move because the next tenancy is not available, is in a much better situation, I think, because you can only remove or force a tenant out based on their own notice or their own agreement by filing an application with the landlord and tenant board. And ultimately, there's a process by which the tenant can ask the board to consider fairness and relief from eviction. And if a tenant says to the board, the place I was going to move into is I'm no longer able to move into, we have some early indication, as I referred to the Superior Court case earlier, that's a sort of sympathetic reason to let the tenant stay a bit longer in their tenancy. So there's at least more of a chance for tenants to escape those consequences of earlier notices that they're no longer able to comply with. Services and facilities, and I'm mindful of the time, so I'll try to get through this quickly and answer any questions. There are a couple of processes under the Residential Tenancies Act for tenants to seek redress for landlords who have reduced or discontinued services or facilities. And I'm thinking mostly of the calls that I've received about tenants in nice condo buildings where they're renting a unit and they thought they were going to have access to like a rooftop pool and a brand new gymnasium, and all that stuff has been closed off by the landlord or by the condo corporation due to COVID-19. And I think the tenant there, and so tenants are saying, well, what am I paying all this money for? Can't I get a break on my rent because I'm not getting all the nice frills or services or facilities that I thought I was paying for? I think at the end of the roads that the tenant might take to obtain a rent reduction is going to be a lot of disappointment for the tenant because first of all, if the tenant is seeking a rent reduction, temporary or permanent, the landlord and tenant board is required to look at whether or not the landlord's decision to reduce the service facility was reasonable in the circumstances, following public health orders and directives. It seems pretty reasonable, I think, to most people. And the landlord could say, we did this not, to be evil, but basically just to follow government direction. Then the tenant in that situation is going to get the equivalent of whatever the landlord was spending to provide the service or facility per month, divided by the number of tenants or tenancies that would have benefited from the service or facility or had access to it. And that is sometimes, the cost of cleaning divided by, 100 units in a building, you're getting pennies back on your rent. It's just not worth it. And in most situations for a tenant to pursue this. Similarly, if a tenant wanted to clarify or wanted to characterize changes in their building as substantial interference with reasonable enjoyment, there's a flexible definition of what actually constitutes interference by a landlord, and the remedies themselves are discretionary. And I think if we just survey, the range of case law on interference with reasonable enjoyment, a landlord that is acting in accordance with directions from public health is going to get a lot of sympathy, I think, and largely a free pass to remove those. So ultimately, this means everybody in many different sectors is losing money as a result of COVID-19. And I think for most tenants who are paying for sort of additional services or facilities that they currently can't enjoy, that's a loss they're likely going to have to bear and not be able to shift to their landlord in most cases. Other rights, just quickly, that we can imagine and that we are imagining will be changed or affected are, the tenant's right to guests. We've heard of some landlords in their buildings just saying, no guests allowed. I'm not quite sure that that is allowed because, of course, the right to have guests and roommates is part of the right to reasonable enjoyment. And so a landlord doesn't quite have that level of authority, but tenants have always borne liability under other parts of the RTA for the result or the outcome of having guests. So I think if a tenant continued to have a lot of guests coming in and out of the building that weren't necessary, weren't coming over to provide, say, healthcare or other kind of necessary or urgent services, but we're just, having a party, having friends over, they're not only risking liability outside of the landlord and tenant world, but also I think their landlord may have some tools to sort of identify those tenants and say, you're endangering safety. And remember, that's the kind of notice of termination and eviction application that the board is willing to hear on an urgent basis. So, tenants, I think, need to temper the exercise of their right to guests using common sense, because I don't think the RTA will protect them quite the same way as it ordinarily would. Repair, we can imagine that when a tenant needs repairs, the landlord may say, well, it's especially hard to accomplish repairs these days. And a lot of contractors don't want to come into the building. And that, on the other hand, I think there's a good argument that tenants who have certain kinds of repair issues in their apartment, think, for example, of a non-working refrigerator, that's going to affect a tenant who has to stay home and eat all their meals at home a lot more now than it ever arguably did before. Like, having a non-working refrigerator is always something, I think, that a tenant had a right to have their landlord repair, and repair promptly, but I'll say all the more promptly, I think, in light of the pandemic. And we're just speculating at this point. There hasn't been time to see these kinds of issues litigated with reference to COVID-19. Landlord entry is something that's caused a lot of anxiety, particularly around showing a unit to prospective purchasers or prospective renters. There are restricted grounds of entry by landlords, usually with 24 hours written notice to the tenant in the RTA. And that, to my knowledge, hasn't been affected the way it has been, for example, in BC. BC has chosen to actually adjust the rules during the pandemic for landlord entry to rented accommodations. In Ontario, no such change has been made. But again, landlords exercising that right of entry are still, I think, and have always been liable for doing so in a way that nevertheless interferes with the tenant's reasonable enjoyment. So now you could imagine, I don't think it's very difficult to imagine that a landlord who just comes in and shows a unit to prospective renters or purchasers every day or every other day without making some effort to really restrict those entries in light of the tenant's likely need to be in the unit and to be kept safe from constantly having other people come and go, is, potentially a source of liability for landlords. And I know that certainly realtors in Ontario, if you look at the Ontario Real Estate Association's guidelines, have largely backed away from in-person showings, especially where there's a tenant in the unit. We've seen a move to sort of virtual tours of properties that are for sale, maybe virtual tours of properties for rent, and then a further sort of set of privacy concerns to consider when you're potentially have a new reason to put video or photos of a tenant's home, which is typically considered private information and personal information, online, and how that's shared is something that will be beyond the scope of this talk, I think. And finally, landlords, owing to sort of popping up a couple places on the essential workplaces list, in Toronto anyway, have been allowed to largely continue quite noisy renovation work on site. And that's only actually been further enabled by the province passing an additional emergency regulation that removes municipalities' ability to restrict the times at which noise as resulting from construction can be generated. So a lot of this kind of regulatory work on the part of the province has been justified by wanting to allow emergency construction of hospitals or completion of hospital and other kind of vital health infrastructure. And somehow developers, landlords, people building condos have all kind of been included in this framework, and the work has continued. And in some cases, it's continued for tenants who are now required to remain in their apartment all day with jackhammering on the balcony right outside their window all day. And that, I think, is going to create some litigation, maybe at the end of the summer, or maybe at the end of, as the Landlord Tenant Board is more willing to hear these types of applications, because arguably whether or not the landlord's carrying out of work is quote unquote reasonable in the circumstances, I think has changed because the circumstances for tenants have changed, and where normally landlords were able to, in a certain way, conduct work during the daytime when they could expect most tenants to be out of their units, that's no longer a reasonable expectation. Tenants can't be out of their units, or aren't supposed to be, for most of the day. Okay, so lastly, beyond all that sort of comment about the RTA context, I want to talk a little bit about what Downtown Legal Services is doing and will be doing as a result of these issues. So, the restrictions resulting from the pandemic really came as we were on the downslope of our semester. Ordinarily, as we head into the exam period, the university exam period, all of our students do their best to put their files into a kind of dormant mode. We try not to schedule appearances. We try to recognize that students are, writing exams, writing papers, and they're less available to us, and they're less available to our clients and our opponents in our forums. So other than sort of managing their files and preparing their files for transfer to our incoming summer students who will start in the middle of May, and they'll start remotely and off-site at the clinic, we wouldn't have been doing a whole lot of certainly no new client intake during April anyway. And so we're lucky that, I guess, that the timing worked out that way. But in the meantime, in addition to sort of taking care of our existing clients, DLS has played largely a coordinating role. So there's been a lot of urgent questions from students funneled through the U of T Housing Services Office, and we're grateful for that partnership. Wherever there's a legal dimension to a student's question, Housing Services is really great about connecting with me and with DLS Housing Division so that we can make sure to supply whatever kind of immediate legal information is most useful to the students who are asking for it. And we'll continue that partnership into the summer. We shot just before the pandemic a bunch of Know Your Rights videos. So for any U of T students, check out ULife, university's student life social feeds on Facebook and on YouTube for a series of videos with Katrina from Housing Services and myself breaking down some sort of basic housing and tenant rights information that you can watch at your leisure. We'll probably also try to have some virtual summary advice drop-ins for students. We also have been privileged to play a kind of central coordinating role because the City of Toronto and indeed the province is blanketed by local community legal clinics with full-time staff lawyers and community legal workers who are now mostly just available by phone and not in person. And so we've tried to sort of float between, and as low-income people, particularly with threats of illegal lockout and other kind of urgent issues, have continued to seek help from their local community clinics and from Tenant Duty Council. We've played a coordinating role. We're tracking, so we have a data tracking project for illegal evictions to see how long it takes to get anybody back into possession who's been illegally locked out. We've been able to continue sort of public advocacy, first calling for the moratorium on evictions, and also continued advocacy around tenant privacy and other rent relief issues. So with that, just discussion about where DLS is and where we're headed as we reopen for the summer and reopen intake, hopefully at the end of May, to individual client calls. I'll take your questions.
Okay, so Raquel here from the Law Alumni Affairs Office. I'm going to read questions from the Q&A section on behalf of participants. So the first question is, could a landlord cancel a month-to-month lease under the Frustrated Contract Act on the basis that they are not able to enforce any measures of the contract in a reasonable time due to the LTB being so far behind? Landlords are left powerless without the LTB to back them up. If so, how would that work?
So I disagree. I don't think that that's an argument that's likely to succeed. It sounds like what the person asking the question is trying to say is that if a landlord doesn't have recourse to the landlord and tenant board and the various enforcement mechanisms, that is so core and fundamental to their rental arrangement that to not be able to do that sort of renders that a big part of the performance of the contract impossible. Because I don't believe the doctrine of frustration really is engaged by the impossibility of minor or subsidiary aspects of a contract. It's engaged by sort of the fundamental a fundamental term of the contract being impossible and being made impossible by something that was beyond anyone's contemplation. So I think that given that the tools that the Landlord and Tenant Board ordinarily provides are themselves meant to redress alleged breaches of contract, I think it's somewhat circular to say that that itself is part of the contract. It really isn't. Like, the contract itself is for the landlord to provide the tenant with a place to live, and that still is certainly possible where for sitting tenants and for landlords, like, you already did it, right? Like, you gave the tenant the keys, they're there, and it's for the tenant to pay rent back. And but non-payment of rent is contemplated by the statutory contract and doesn't immediately void the other parts of the contract. So no, I don't think that frustration will lead to any one or all tenancies being ended because the landlord doesn't have the same immediate set of tools to punish tenants with. But of course, that's my view as a tenant advocate. It's an argument that I think landlord representatives are free to try. I don't think it's going to get them very far.
Okay, great. So the next question, is there any vision for legislation that would create a right to rent strike?
You know, that's an interesting question because the legislation right now contemplates tenant associations and actually says that the Landlord and Tenant Board is required to refuse eviction where they think that at least one of the reasons why the eviction application has been brought is because the tenant was engaging in tenant association organizing activity, to paraphrase. So there's some minimal protection to sort of say, you know, landlords aren't supposed to reprise against tenants because they're organizing. And tenant withholding of rent has a long and interesting legal history in the jurisprudence. It's something that back in the 70s, when the legislation was a lot newer, some people thought that indeed that's what the legislation had enabled, one of the major changes they believed had been made was that, you know, if a landlord is breaching a part of the tenancy contract, like failing to do repairs, that would enable and give tenants the right to withhold right away. I don't really, I don't believe or foresee that that a sort of managed framework for rent strikes, the way we have a managed framework for labor strikes, is coming anytime soon. I haven't heard of anyone in any political party in any level of government seriously propose that. It's an interesting question, I guess, to consider from a regulatory perspective.
Okay, next question. Thanks for this presentation, Ben. This is Julia from PBSC. Can you give us some examples of permissible discrimination you have seen against a boarder who is exempt from the protections of the RTA and the code? Have you seen this play out in any particular way in the pandemic?
Yeah, I should say also some of my colleagues in the human rights and housing sector have mused that exemption from the code might be vulnerable to a charter challenge because, you know, much the same way as Vreen in Alberta, you know, targeted provincial human rights legislation that was incomplete, and by being incomplete or by cutting people out of its protection was itself discriminatory. So there's some, we should probably question whether or not that provision is even constitutional, but certainly the duty to accommodate disability within housing is not there for boarders. So if a landlord has a boarder and the boarder has a disability related need, that a landlord would normally have some obligation to meet, whether it's through putting in place modifications to the unit or to the landlord's practices that meet that tenant's disability related needs, don't carry over at least at face value because of that exemption from the code. You know, another easy one would be, you know, landlords of, you know, RTA exempt boarder accommodations that discriminate on the basis of sex or race when offering their tenancy. And then there's some further debate about whether or not that nevertheless constitutes discrimination in the offering of contracts. But I think I'm not aware of a case that actually fully examines the scope of that exemption. I don't think it's very often litigated.
Okay, next question. Is there a legal basis to request for rent reduction of rent as one of the co-renters is moving out, and is it difficult to find? And it's difficult to find a co-renter.
Mostly no, and a little bit yes. So mostly no, I'll say, because when multiple tenants are in a joint tenancy, typically what they've agreed to is rent a single, hopefully, or maybe multi-bedroom unit that they're all jointly and severally liable for. And that means that if one of them moves out, the rest remain jointly and severally liable for the whole rent. Typically, they should try to find a replacement roommate who can kick in some money and help them meet their monthly expenses. There is a kind of narrower area of rental housing law that debates whether or not joint tenancies, particularly of multi-bedroom units, can be converted to tenancies in common or separate tenancies, and under what circumstances. It's really too complicated to get into in the time that we have, but I would say most of the time, what the question describes is, somebody moves out and so they're no longer contributing to the rent. They may still be liable nevertheless, and the sitting tenants would also still be liable. So there's no formal basis in the RTA for reducing the rent based on the number of people. And that works the other way too, that landlords aren't allowed to increase the rent as a result of a household growing, which some landlords will try to do if they're not aware of that portion of the law.
Next question. Hi, Benjamin. If a tenant pays for a service like parking as an item separately listed in their rent, and they stop paying for only that portion, can that person eventually be evicted for that underpayment, or do they simply lose the service once LTB resumes eviction?
Well, that's really interesting because, as far as the RTA is concerned, even though a landlord may show segmented charges for parking or other individual services or facilities separate on a ledger or an invoice, I think the RTA considers all of that to be rent, and there are provisions in sections 123 and 125 of the Act for a landlord and tenant to agree to add a service and increase the rent accordingly by that nominal amount, and then to later remove a service or facility and decrease the rent by the same amount. And so I'd have to revisit the provisions to see under what circumstances a landlord can say, no, I refuse to remove this service or facility from your lease. You still have to keep paying for it. Most landlords in practice, I don't think, do that if they have other tenants who might want the same service or facility, or it may be that the landlord and tenant have already agreed that, pre-agreed for a procedure for the tenant to say, I no longer want this service or facility, and now my rent will be reduced by that segmented amount that I was paying for it. But I think I wouldn't rule out the possibility that a tenant that just on their own decides to stop paying for their parking and stop using their parking gets immediate relief from the money that they were paying for parking. A tenant, in the very least, needs to give some heads up to their landlord, and I would think the tenant would be safest to try to obtain their landlord's agreement to remove the service or facility. And I at this point, without double checking my references, I would not rule. I think actually a landlord is in a position to insist that a service or facility remain a part of a tenancy if that's what's been offered as a package deal. So that's. I think there's some landlord agreement required to remove a service facility and lower the rent accordingly.
Next question. In a joint tenancy, is there any rights granted under the RTA to sever a specific joint tenant's interest and unilaterally leave the unit and the joint tenancy? And if this is possible, does the landlord then gain the rights to force a replacement tenant on the group of joint tenants?
Only in the situation where it can be argued that the joint tenancy has been converted to several different tenancies, and that's not formally contemplated by the RTA. It's in a practice direction that the Landlord Tenant Board has. So it's how the board interprets what constitutes a tenancy. So to get ourselves a little bit out of those weeds, though, there is an explicit set of provisions that were added to the RTA to allow a joint tenant to extract themselves from a tenancy and from their rental obligations without the agreement of their roommates or fellow joint tenants, where there's been domestic violence. And so those specific provisions correspond to specific notices that a tenant that has experienced violence or domestic violence in the rental unit is able to give notice to the landlord that they are terminating and severing their interests and moving out. And then my recollection is that the Act further provides this sort of timelines for the remaining tenants to decide whether they also want to terminate the tenancy and all move out thereafter, or whether or not they want to continue, but now responsible for the whole rent because it remains a joint tenancy. So it'll be rare that a landlord is allowed or permitted to impose a new tenant on unwilling joint tenants in a single rental unit, unless they can prove that it was always a set of several different tenancies, which doesn't quite turn on what people prefer. It's more related to the circumstances of how the rental began and the layout of the place.
Okay, so this is our last question, and then after this presentation, we'll make the recording available to everyone. Okay, so if there is still a liability of missing rent payment, would the small claims court help?
There's still a liability of missing rent payment. I think if I understand the question correctly, you mean for sitting tenants? Like I don't fully understand the question, but I can try to answer. So currently the small claims court has jurisdiction over breach of contract claims arising after the tenant has moved out when they're brought by the landlord. That is to say, the tenant needs to be in possession of the rental unit if the landlord wants to be able to, get money for rental arrears or for damage caused to the unit for that matter. As soon as the tenant has moved out, if there are no active applications at the landlord and tenant board brought by the landlord, they're supposed to be able to file within a 2-year limitation period an action in small claims court for the same amount. The small claims court, practically speaking, is just as shut down as the landlord and tenant board is, in my anecdotal observation. And beyond that, there was some case law coming out of last summer that really cast doubt on any landlord's ability to access the small claims court for those types of claims. It was called Kisselman, and it's a case from the divisional court that threw, I understand, a lot of my colleagues on the landlord side into real throes of uncertainty. And in fact, just before the pandemic became kind of the province's sole focus, there were a package of proposed RTA amendments that would have taken all of that out of the small claims court and allowed tenants to be pursued by former landlords still at the landlord and tenant board. That legislation, I think, is completely stalled out. It's just not a priority for the province right now. But it would have been one potential resolution to Kisselman. The other would have been finding that Kisselman is bad law, because I think it very likely was bad law. And so yeah, whether landlords can pursue their tenants at the small claims court requires the tenancy to be over, and it requires the tenant to have moved out already. It also requires the small claims court to have hearing actions. And finally, it requires someone to have resolved this issue of Kisselman, which may or may not be coming in future RTA amendments. We don't know.
All right, great. Thank you so much, Ben. We appreciate it.